Good morning. Welcome to all of you. Welcome to our WorkLaw subscribers. Also a big welcome to you, of those of you who what we call are not yet WorkLaw subscribers. And we hope you'll become WorkLaw subscribers soon. Just a few issues. Alan Rycroft and I, Bruce Robertson, will be taking you through the material on chairing inquiries effectively. We're going to talk for probably about an hour, and we'll take questions at the end. So if you have questions, use the Q&A function at the bottom of your screens to post questions as we go, and then we'll try and answer your questions as best we can at the end of our presentation. We are recording this webinar, so there's no need to take notes, and we will make the recording available on the website, on the WorkLaw site after the webinar. We aiming to make this a very hands-on practical workshop. We're going to cover some fairly basic stuff. At the same time, we hopefully will get into some of the more complex issues as well. So we hope that each of you will be able to take something away from this webinar, some learnings that would help you in chairing inquiries. Alan, anything that I ought to have covered in this opening intro that I haven't covered?
No, I don't think so.
Let's go. Let's look at, I'm going to share screen, and let's look at some of the learnings that we hope to achieve in this workshop. Slide through from the beginning. Alan, take us through some of the key learnings.
All right, we're going to start with framing disciplinary charges. It seems to us that a lot of mistakes are made because the disciplinary charges are framed too tightly, too legally. And we want to look at some recent cases which give some clues how to do this. Then we want to move on to how does a disciplinary chairperson avoid perception of bias? Almost the first thing that happens when someone is found guilty of the charges is they say that the chair was biased. And we think there are ways you can actually avoid that. Then we want to look at dealing with objections. Objections are often raised at the beginning, sometimes with the intention to delay or even stop the whole proceedings. And the chairperson's got to have the skills how to know how to deal with objections. Then we want to talk about managing the evidence phase. Because this is a rational process, you've got to base your decision on the evidence, and that comes in two forms. Through witnesses, Bruce, through witnesses, and also through documents. And we will look at different aspects of that evidence. Then something which we think is quite important is how do we as chairpersons, when should we ask questions? Because that becomes quite an important way of preventing the hearings carrying on indefinitely. And then we want to end up by saying, how best do you write up the outcome of the disciplinary inquiry? So we hope that through these key learnings, we'll pass on some rather basic, but also some practical help.
Yeah.
We thought it'd be good to root our discussions with one particular scenario in mind. And we've chosen quite randomly the following scenario. An employee is charged with being under the influence of alcohol at work. He's observed by the manager smelling of alcohol and bloodshot eyes. You look worried, Bruce.
That's the way Alan looks most mornings, but we will pass on over that.
The employee worked for 2 hours without incidents. He was required to take a breathalyzer test and failed. And finally, he admitted drinking the night before and got to bed around 3 a.m. He claimed he didn't drink after that, and he wasn't under the influence. So this, if you can just bear this scenario in mind, we'll refer back to it when we're thinking about charges, about evidence, and so on. So we hope this roots this morning's webinar.
Yeah. If you look at the typical outline of a disciplinary inquiry, there are really 3 phases to an inquiry. There's the intro phase, where you as chairperson would introduce all the people present, make sure they all know who they are and the reasons why they're there, and you would explain the process to the parties. It would also be the opportunity to understand what the employee's response to the allegations against him and her are, whether they have broken these company rules or not. If you want the legal jargon, and we're going to be saying avoid legal jargon, but are they pleading guilty or not guilty? Then your job as the chairperson is to find out what happened. You weren't there when these issues occurred, and you will have to manage the evidence phase of the inquiry, and you'll then have to make a finding based on the evidence that's placed before you. And then, based on your finding, if you found that the employee has broken certain company rules, what would be the appropriate outcome or sanction to be applied? And you'd consider factors of mitigation and aggravation, and advising the employee then of the outcome of the inquiry. So we know and understand that many organizations do inquiries in different ways, but probably all of them in some shape or form take you through these three phases of the inquiry, and we're going to look at practical problems that might arise at each stage in the process. Now, we know that the Unfair Dismissal Code of Good Practice talks about the need to conduct an investigation, which implies something more informal. We're going to be giving you an outline we think that is practical. Some of you may think it's a bit too formal, but we think, well, there are two important points to make. Firstly, that we think it gives you the best chance of avoiding allegations of procedural unfairness if your matter gets taken on to the CCMA or to a bargaining council. But we also, more importantly, think by following the structured approach that we're going to be giving you, gives you the best chance to get the outcome right, to give a fair outcome, to arrive at the truth of the matter, which is what you're trying to achieve, is to arrive at the truth of what actually happened, and then based on that, decide what the fair outcome should be. So we're going to look at practical problems at each stage in the process. So to begin with, in the intro phase.
Well, I think the important thing to realize is that if you have a policy or a procedure, an employer's policy and procedure, you must follow it. The reason why I'm saying this, the CCMA's code on the running of misconduct arbitrations makes it quite clear that the employer is required to stick to its own standards. And so if there is a policy and a procedure, you must follow it. But if you don't have an internal policy or procedure, work law under its precedence icon has got checklists on how to conduct a disciplinary hearing and on issue of warnings. And there's also, to make it easier, there are some forms you can use. There's a form of a notice to attend a hearing, to a record of the hearing, and a form to notify the outcome of the hearing. So please use these forms. They're free on our site.
Yeah, and those are just examples of some of the checklists and forms which are there. There are others as well. So as Alan has said, follow your own procedure and checklist. Secondly, it's crucial for you as the chairperson to set the fair tone for the inquiry right up front. You are the custodian of fairness. You are having to give a fair outcome and follow a fair procedure, and you need to set the tone right from the start. And that would go a long way to ensure that the inquiry is conducted in a fair and proper manner. Clarify the roles of the parties. For example, HR, if there's an HR person present, make it clear to the parties, this may be the first inquiry they have ever had to attend. Make it clear to them what the role of the HR person is. Is it to advise both parties on procedure? Is it to advise the chairperson of previous cases and what sanctions have been applied in previous cases? So when the HR person then intervenes and is doing what they should be doing, it's been explained up front and it comes as no surprise to the parties. Outline the process. We often used to get, we don't do it that often anymore, but we used to get called upon to, as an independent person, come in and run internal inquiries. I would spend a good 15 minutes to half an hour explaining the process to the party so that they have a clear understanding of how the process will work. Say up front that you as the chairperson may ask questions of clarification, so that when you do then start asking questions, it doesn't come as a surprise to the parties. And I'm going to speak later about how and when you as chairperson should ask your questions. Objections. I'm just going to go out of screen sharing at this point. Dealing with objections is an important function that you as chairperson would have to do. And these might be objections up front as you begin the process. There might be an objection to you as the chairperson. There might be an objection at a later stage to the kind of evidence that's being led or the kind of questions which are being posed to one of the witnesses. How you deal with objections is crucial to the conduct of a fair process. And those facts that Alan outlined earlier, say you begin the inquiry, you're just beginning to explain the process, and there's an objection to you as the chairperson to say you're likely to be biased. You've dealt with cases before involving people drinking at work, and you've always taken a harsh approach, and they don't think that you're going to be fair in conducting this inquiry. Don't just immediately rule on the objection or respond. Turn to the union person or the employee and say, help me understand the basis of your objection. Listen to what the person's saying. Again, when they've motivated their objection, don't answer. Turn to the management rep and say, there's been an objection against me as the chairperson. What's your view on the objection? And listen again. Allow the person to say, no, we think that you'll be fair, that you'll base your outcome on the evidence that's placed before you, etc., etc., etc. Again, don't intervene even at that stage. Turn back to the union or the employee and say, you've heard management's response to your objection. Do you still wish to object to me as the chairperson? And I've used, and I'll use this later in this talk as well, sort of ping pong or table tennis or a game of tennis where the ball bounces backwards and forwards across this net. And you're allowing each party to comment and have their say on issues, which is the, if you want the legal jargon, the audi alteram partem principle, the right to be heard, the right to express yourself. And both parties have now had an opportunity to express themselves on the objection, and then you can make a ruling at that stage. It's also given you time to think. You don't have to respond immediately. And as this process is going on, you're formulating your thoughts as to what you think about this objection. If you feel that you can make a ruling on the objection and advise the parties that they obviously have a right to take this matter further at a later stage if they wish to refer this matter to the CCMA, etc. If you are still unsure, having allowed the parties to express themselves, then you can adjourn the inquiry for half an hour, a day, bounce it off someone else perhaps, and then come back and make your ruling and continue with the process. So I hope that's been helpful for you, those of you who've chaired inquiries in the past and have had problems with objections. I hope that's helped you in how you would deal with objections. And obviously, if there are any questions on that, you can raise them and we'll deal with them at a later stage. Use the Q&A function at the bottom of the screen. All right, I think you're back looking at the PowerPoint.
I want to just talk about that moment where the employee admits that the misconduct was committed. Most employer reps at that moment are very relieved because it looks like the matter is going to be concluded quite quickly. Well, one of the consequences, of course, is that you don't have to need any evidence of the misconduct. But we've had a number of instances where subscribers have said that after pleading guilty, as it were, to use those terms, the employee didn't realize at the time how serious the employer was taking the matter. They didn't realize that they were in dismissible territory, as it were. So we think it's probably wise for the chairperson to just take a moment to say something like this. I just want to make sure that I understand. You've admitted that you tested positive for alcohol use during working hours. Is this correct? And do you understand that this is a serious form of misconduct? I think it's really useful for the chairperson just to make sure the person is aware that it's serious.
Yeah, and also, using if there was an assault has taken place, and if the employee admits the assault, assault can take various shapes and forms. I mean, I can say that, and I'm gonna beat you up. That's an assault. And assault also, you punch someone on the jaw and you break their jaw and they're in hospital for 6 months. So some of the details of the offence might be important. And if you're the management rep in the inquiry, you might want to explore a bit further what exactly is being admitted.
Sure.
So there's no need to then have to prove these things when you get to the aggravated phase of the inquiry.
Sure. Yeah. Just got to check.
Yeah, moving on.
A number of issues have been raised with us about the way disciplinary charges have been framed. And very often there's a tendency to make it almost like a charge in a criminal matter. You are charged with theft in that on this day you removed X, etc. And the use of the legal terms often result in a person being found not guilty, because if you have charged with theft or fraud, the law, the criminal law anyway, requires you to prove intention, which is very hard to prove. I think it's worth reminding ourselves as chairpersons that the overall objective is to make a decision whether there's been misconduct, just that term, misconduct. Of course, it comes in various forms, a huge variety of forms. And it's worth bearing in mind also that the Code of Good Practice on dismissal simply requires that the employer should notify the employee of the allegations using a form and language that the employee can reasonably understand. So the purpose is to alert the employee, look, this is what you're facing, you better come in with a story to tell us. And of course, it remains a problem how to classify it. And I think what I'm trying to say is, don't rush into classifying it as fraud, as theft. You can just describe what happened.
Yeah. Do you want to comment on splitting charges at all?
I can. No, I'm going to do it a bit later.
Okay. All right.
I want to just talk about two cases which I think are helpful. There's this EOH Ubuntu versus CCMA case. Principle emerges there. The charge must be specific enough for the employee to understand what misconduct has been alleged. And it goes on to say the employer's categorization is less important. Another Labour Appeal Court case, which I think is a very useful one, is the Sol Plaatje municipality case. Now, just as a bit of background here, the employees were charged very precisely that on a particular day, they removed they stole an air conditioner from the roof of a hall that was owned by the municipality. And the time and date were given, and they used the word stole. And the employees were found guilty because the disciplinary chairperson did not believe that they had proved all the elements of the charge.
So they were found not guilty.
Found not guilty,
yeah.
for the precise charges. It went all the way to the Labour Appeal Courts. And the court, once again, this isn't new, said there's a major difference between disciplinary matters and criminal proceedings. And there was a need to unduly, to avoid the technical approach to framing charges. They suggested you almost describe in story terms that the misconduct, you're charged with misconduct in that you removed an air conditioner without authorization. And that's simply often a yes or no kind of test. So in the scenario we were given for discussion about the alcohol, if you went technically and said that you were under the influence of alcohol, you've got a whole difficulty of proving what would it mean to be under the influence. If you choose to describe the misconduct of proving positive to an alcohol test, it's a yes or no answer, far easier.
Yeah.
So as Bruce mentioned, splitting charges is also something we've got to be aware of. Sometimes employers like to take a single incident, and for example, let's use the alcohol scenario we've chosen, to take the actual offense of being intoxicated in the workplace, as well as proving positive, testing positive, but they will add on things like disobeying instructions not to drink during working time, and then they might add in insolence or might add in bring the employer's name into disrepute. Now, the courts have been quite firm about this. They said out of a single incident, you can't split it up into a number of charges to make it seem more serious. It's an act of misconduct, which may be serious, but you can't, the employer mustn't seek a heavier sanction simply because it's been broken up into different forms of misconduct.
Yeah. All right. Just a quick note on if you're having to take disciplinary action against a shop steward. The shop steward appears before you at a disciplinary inquiry. If you're the chairperson, you need to check whether the organization has fulfilled its obligation to, and as it's put there, inform and consult the union. And this comes out of the unfair dismissal code of good practice. That's quite hard to do in advance of the disciplinary inquiry, because yes, you can inform the union that there's an inquiry coming up, but it's quite hard to consult when you don't yet know all the facts which are going to emerge at the inquiry. So one of the ideas that we often say to employers is to agree with the union that the employer's obligation in terms of this section will be fulfilled by allowing a union organizer to represent the shop steward at the inquiry, because they're obviously then informed, and obviously by being part of the inquiry, they've been consulted in the process. And you agree up front that this is deemed compliance with the obligations under that section.
I say it's worth remembering the purpose of this.
Yeah.
The purpose of this is to avoid victimization of people who belong to the union.
Yeah.
And so by consulting or informing and consulting, it's a way of assuring the union that the employee is guilty of misconduct and you are not victimizing.
Yeah. Just there is one case on this. It's a Labour Appeal Court judgment in 2006, and it just made the point that this obligation applies not only to recognized unions, representative unions, and interestingly enough, the Labour Appeal Court in this case said, well, that was only a guide because the employer hadn't complied with this, and they asked whether there was any prejudice by the employer's failure to have done this, and it found in that case that there was no prejudice. So if you slip up and you don't comply with it, which we obviously advise that you do, this case might help you in that you can argue as to whether there was in fact any prejudice over your failure to do so or not. Moving on, so that's the end of the first phase, the intro phase. And obviously if you have any questions, put them up under the Q&A function and we'll deal with them at the end of the workshop. Moving on now to the next phase, to the second phase, which is to find out what happens. And that's really managing the evidence phase of an inquiry. And when a witness gives evidence, there are really three phases to this. Again, I'm using this table tennis analogy of a ball bouncing across the net, going backwards and forwards. Say management calls the manager who observed this employee and ordered that he undergo a breathalyzer test. Management would ask questions of this witness and ascertain those facts from him or her that they think are important. The ball then bounces across the net to the union or the employee, and they can ask their questions of this manager. They're not restricted to only asking questions around what was said when management asked their questions. They can ask any questions they like that are important. So they can ask questions to deal with issues that were raised by management, but they can also perhaps raise new issues. And the union, in this case, maybe then asking the manager about questions about what he observed. Was this employee doing his job normally? Was he able to work normally? Issues that may not have been raised by the management rep in their questions to the witness. So these new questions now, if you think about the ad alteram partem principle, the right to be heard, both sides need to be able to comment on each other. After the union has asked their questions, the ball bounces back across that net to management side, and they can ask further questions to deal with the new issues that may have been raised by the union. If you want the legal jargon, examination in chief, cross-examination, re-examination. But again, we're saying as chairpersons, avoid the use of legal jargon. Talk about asking questions. Don't talk about cross-examination. So there are three phases in that process. I'm going to talk a bit later about when you as the chairperson should ask your questions. But just moving back into the PowerPoint, I want to talk briefly about this obligation to lend a helping hand. I know this came up in arbitration. It's a Labour Appeal Court judgment, and it applies more to arbitration than to internal inquiries. But there's an obligation under the CCMA's Code of Good Practice on arbitrations for arbitrators to what's called lend a helping hand, to guide unrepresented, non-legally represented parties in how they handle the evidence phase of the inquiry. And the arbitrator's failure to do so in this matter led to the award being overturned by the Labour Appeal Court. And I think even though, as I said, this judgment applies particularly to arbitration, I think the same principles will apply to you as chairpersons. You're going to have people appearing before you. They've never attended an inquiry in their lives before. And this is new ground for them. And you need to make sure the parties understand the process and know what's going on and know that when it's their opportunity to ask questions and so on. And you need to engage the parties if they're not using the process properly. One of the points I'm making is when you do intervene, make sure that you're giving advice, if that's the right word, both to the employer side and the union side, that you're not seen to be only advising one of the parties in how the process should unfold. Okay, moving on. We've dealt with that. Alan, do you want to talk about these issues?
Sure.
In one go?
Yeah.
Open and leading questions, hearsay evidence, and documentary evidence.
All those three aspects, which I'll deal with now, are because it's our duty as the chairperson of a disciplinary inquiry to base our decision on reliable evidence. And what I'm about to say also, this distinction between open and leading questions, I know it's perhaps a bit legal and that more important than arbitration, but there's a real difference between evidence which comes from an open question. When was the last time that you had a drink? And that comes voluntary from the witness, 3 o'clock in the morning, as opposed to, is it correct that the last time you had a drink was 3 o'clock in the morning? Yes. Yes, it's true that it's just as chairpersons, we're making notes and we're writing down 3 a.m. in both cases. But when the answer comes directly from the mouth of the witness, it's just more credible. And so you can usually pick up a leading question, which is in arbitration and court, not allowed in the evidence in chief stage, where the person is going to tell their story out of their own mouth in a logical kind of way, a clear way. You're meant to only ask questions which are open questions, and they usually are identified with words what, when, how, where, and why. Those are the questions which elicit an open-ended question, open-ended answer, whereas a leading question is usually identified with did, do, is, were. Those kind of, when the question starts with those words, you can be sure it's a leading question. And you as a chairperson must know that the answer is going to come in the form that's less reliable than if the question is an open-ended question. Now, I think in disciplinary hearings, it's not likely that someone's going to say, objection, this is a leading question. But you as a chairperson, I think, can gently guide that helping hand principle. Say, look, I think the questions you're asking would be better if they were open-ended. So that's how I would advise you to proceed. Is that okay? Give me an example tied to our scenario. You said that because you finished drinking at 3 a.m., you were not under the influence of alcohol when you came to work. Your manager has said that you smelt of alcohol and had bloodshot eyes. Isn't it clear that you were still under the influence of alcohol? Isn't it clear the person can say yes or no? It's not really great evidence, is it? I mean, you're not going to expect the person to say, yes, I was definitely under influence. You get a very weak answer. So the more open-ended, I think the more reliable evidence.
Do you want to comment on the use of leading questions, though, in cross-examination?
Yeah, so it's understood. Well, first of all, can I say, even in that evidence in chief stage, it's understood that there's a room for the leading question. Bruce, you are the HR manager of the employer, are you not? Yes.
Because there's no common cause.
That's right, and also it speeds up the thing.
Yeah.
But at the cross-examination stage, it's far easier, and in fact, it's quite acceptable for you to put a version. It's just been, the manager has just said, this, what's your comment? Is it true that you were arrived at bloodshot eyes? In cross-examination, it's almost expected that you will ask a leading question.
In fact, that's how cross-examination normally takes place.
Correct.
So putting your version as a leading question.
Correct. So you're testing almost an established version.
Yeah.
I want to speak briefly about hearsay evidence. Let's imagine in our scenario that the manager who saw the employee with bloodshot eyes and smelt the alcohol was away on holiday and couldn't get evidence, but he told another manager, and she comes along to the disciplinary inquiry. So you can just see how this evidence would be. Our manager who witnessed this isn't here, but he told me straight afterwards what he saw. Now you realize at that moment that you can't really cross-examine somebody who's been told the story. All that they can give evidence is that they were told the story. We don't know if the story was correct. And so in legal terms, this is called hearsay evidence, a strange old ancient English word. And it means evidence which can't be tested because the main person is away. Now, most documentary evidence is hearsay, and there is forms of hearsay evidence which is routinely accepted. Doctor certificates are a form of hearsay evidence because it's impractical to ask doctors to keep on coming to disciplinary inquiries to testify about a medical certificate. And so what's on the doctor certificate, the employer usually accepts, sometimes reluctantly, but accepts. So yes, it's true that there's some hearsay evidence is accepted, but we as chairpersons must accept that hearsay evidence is weak evidence. An affidavit is just a document. You can't cross-examine an affidavit. So the fact that a person slides over an affidavit and says, this proves the case. Yes, it might be a form of evidence, but it's weak evidence. So be alert to the form of evidence you're receiving. And ask yourself, is there somebody who should be talking about this evidence who was involved personally? Yeah. Which leads me to the documentary evidence.
Can I just comment on affidavits, because I think it's important. If, for example, someone's immigrated and they're not available to, although you could also now with modern technology conduct an investigation via Zoom. Let's say someone's passed away, but there's an affidavit from that person. Well, that's the best evidence that there is. So it's admitted. How much weight or importance you attach to it will depend on the facts of each case. If a manager from the plant says, I'm too busy, I can't come and attend your inquiry, but here's my affidavit. Well, that's not the best evidence that you can get. Yeah. Getting that manager present to give evidence. So as chairperson, you might say, I'm not going to accept that affidavit. If that manager wants his evidence to be taken into account in this inquiry, I'm going to adjourn the inquiry and he must come personally and give his version of events as to what transpired.
Yeah, thanks. which leads us on to documentary evidence. And the term documentary evidence is perhaps the legal term to describe a whole category of evidence that includes documents, photographs, plans, videos, tapes, and objects. Now, this might not happen in a disciplinary inquiry, but it usually happens in arbitration where the company will arrive very organized with a bundle of documents. Look, a union might as well, but it's more from the union, the management side, it'll come with a bundle of documents. Now, you as disciplinary chair, if this happens to you, that doesn't become evidence, and it's been explained to you what that document is. So someone from who wants you to accept the documents in the bundle is going to say, document A are the minutes of a meeting we had on this date. And if the other side would say, yeah, we agree, those are minutes, that evidence then that gets accepted into evidence. And I'd say the next document, this is an email we sent to all employees explaining that there's a rule about testing positive for alcohol. And the other side might say, yes, might have been said, but we don't recall ever receiving it. It then becomes a slightly suspect document, because then there needs to be proof that that email was sent and it was received by everybody. So each document and every video and everything has got to be introduced in evidence. It's going to be before it doesn't just jump in for us disciplinary chair people to then accept it as evidence and start to make a ruling on it. It only becomes evidence once it's introduced and it's been accepted.
So as chairperson, if documents are placed before you, the first question to ask the parties is this document admitted between the two? If it's admitted that it exists and it was given, or depending on what the facts are, if it's admitted, then it can be banked as evidence. It's in. It doesn't have to be proved. But if it's not admitted, then the party who's seeking to rely on that document needs to prove what they want you to draw out of that document by calling a witness, etc.
Yeah.
All right. Just going back to shared screen and calling up the PowerPoint. We've dealt with open and leading questions, hearsay evidence, documentary evidence. I'm going to deal with this notion of putting aversion to a witness, and as a chairperson, when to ask your questions. Now, if you were lawyers appearing at arbitration or in a labor court matter, you would know that when you cross-examine, when you cross-question the other side's witnesses, there's an obligation for you to put your version. In other words, to challenge any aspects of what that witness has said by putting what your version will emerge when you call your witnesses later. And your failure to do that, your failure to put your version to that witness may well be regarded by the arbitrator or the judge in that matter as proof of it. Well, you didn't challenge that version, therefore I'm going to take it that version was accepted, and I'm going to accept that version in this process. Now, clearly in your internal inquiries, you haven't got lawyers, and you can't apply those strict legal principles. But it's through the process of versions being put to the witnesses that, in fact, you are best able to test which is the more probable version of events. So let's assume those facts that Alan was talking about earlier. Let's assume that management has called the manager. He's given evidence about that he was called by the supervisor to come and observe this employee. He arrived there, he saw him with bloodshot eyes, and he smelt of alcohol, and he ordered that he undergo a breathalyzer. Let's assume that the unions now cross-questioned that manager, and all they've asked about is what the supervisor said to the manager when he asked him to come and inspect or observe this employee. You know, as chairperson, from the intro phase of the inquiry, that the employee's defense was that he wasn't under the influence. Yeah, that he drank, he had a drink the previous night, he had a dreadful hangover, but he wasn't under the influence. He was able to do his job normally. Now, you know that, and yet both sides have now had a chance to ask their questions, and no one's raised this. So when do you as chairperson ask your questions? If you ask them too early in the witness process, it's going to irritate the parties and it's going to interfere with their line of questioning. If you ask it too late, then you're not going to give the parties the opportunity to ask their questions arising out of issues that have surfaced because of your questions that you've asked. So going back to that table tennis analogy, management starts, they ask their question, the ball bounces across that net, the union or the employee asks their question. The issues that you think are important still haven't been raised. So at that point, as the chairperson, ask your questions. Ask open questions, not leading questions. So don't put words in the mouth of the witness. Ask open questions and say, help me understand, Mrs. Manager, when you arrived there, tell me what you observed. How was this employee performing his duties? And get the evidence that you wish to, that you think is important. Having answered your questions, say to the union, have you got any further questions to ask arising out of the issues I've now raised? They can then ask any further questions if they want to do. Then the ball bounces back across that net to management side, and you say to the management rep, have you got any further questions to ask arising either out of the issues that I've raised as chairperson or out of the questions being asked by the union? Think about what you're doing. You are fulfilling the audi alteram partem principle, the right to be heard. Both parties have now had a chance to respond and deal with new issues which would have been raised by you as the chairperson. It's going to minimize the perceptions of bias that might be created, because you might have asked a key question that might influence the whole outcome of the inquiry. Also, an important point, if you are asking questions, and I as an arbitrator, when I used to arbitrate a lot or chair inquiries, I tended to ask lots of questions. Make sure you're asking both parties' witnesses questions, and don't only question management's witnesses or only the union's witness questions. Make sure you perceive to be even-handed in how you're dealing with both parties' witnesses. So we've dealt with putting aversion to a witness, and we've dealt with now, hopefully, the chairperson when to ask questions. Just on perceptions of bias, which might be created, this Labour Appeal Court judgment gave the test for bias. It's whether a reasonable, objective person would apprehend bias. And obviously, to avoid a perception of bias, you must be open to persuasion, as equally open to persuasion by both parties' evidence. Just an interesting judgment. It's quite an old judgment, 1997 judgment, a Mondi judgment. In that case, I think the employer was quite fortunate, and the Labour Appeal Court found that there was no bias, even though the chairperson had caucused with management during the hearing. We would not advise you to caucus as the chairperson with one of the parties. Ellen and I gave a similar webinar to a company recently, and in their policies, they allowed the chairperson to caucus with the management rep in order to decide on what sanctions should be applied. Now, again, I think it immediately creates the perception of bias if you're caucusing with one of the parties about what the sanctions should be. So avoid that. Avoid being seen with the management rep during the course of the inquiry. All right, moving on. You now have to make a finding on the facts. Ellen.
Yeah, and this is the moment actually that I remember as when I chairing a disciplinary inquiry, it's a very conflictual moment for the chairperson. Even though it is might be very clear where your heart lies, you know you've got to make a decision based on the facts and on the evidence. And it's at that moment that I think we've got to remember what the tests are in our law. And the question is, how certain do you have to be? And it's not the criminal law test of beyond all reasonable doubts. And that test is a very strict test. It really means that as soon as a reasonable doubt has crept in, the judge has usually, or the magistrate's got no option but to find the person not guilty. Illustration was in that famous case, Shreen Diwali, some years ago, where the husband arranges for the murder of his bride in Guguletu. For those of us reading the story in the newspaper, it was absolutely clear that there was total guilt. But the judge was conflicted with very doubtful evidence and had no option. And she was criticized in her judgment for going that route. But it illustrates that our job, fortunately, as chairpersons, is not that criminal law test. It's a strange test of balance of probabilities, which is using our common sense of working out which of the two versions, if there are two versions, is the more likely, the most probable. And so in our case here, let's imagine the charge was being under the influence of alcohol rather than testing positive. If that was the charge, the charge was being under the influence of alcohol, the discipline chairperson is having to balance the evidence about someone who drinks until 3 a.m., arriving at work with bloodshot eyes and smelling of alcohol, against the evidence of a person who works for 2 hours with no difficulty, it seems. And you'll have to work out which version is more probable. Not an easy thing often.
Yeah. What do you do if you find the person is not guilty of breaking the company's rules?
It's very interesting, the number of disciplinary chairpersons who make a mistake at this moment. They say they found the person not guilty of being under the influence, but feel that they need to show some kind of displeasure at what's happened, and says, well, I'm still going to find you, I'm going to say that there should be a final written warning. Once you've decided the person is not guilty, that's the end of the matter.
Yeah. I think what often happens as well is that the person's not that sure on the evidence, and they say, well, this is a dismissible offense, but I'm not that sure, so I'm only going to give the guy a final warning.
Yeah.
You can't do that. If you find them on a balance of probability that they're not guilty, I mean, that's the end of the matter.
Yeah.
You can't impose a lesser sanction because you're uncertain of what the guilt might be.
Yeah. Something which we've found useful is at the moment of making your decision to go back to clause 7 of the Code of Good Practice on dismissal. And it sets out, I think, a really fabulous guide for helping a chairperson reaches a conclusion. And this is how it's set out. It starts off, is there a company rule in place? And that covers, there are going to be situations where there's not a company rule affecting a scenario. There'll be a couple of CCM awards that have been reported already where the company didn't have a clear rule about the wearing of masks during the COVID period. And they had tried to put up, establish a rule through notices on the boards. And that'd be a case where a chairperson, you have to say, yes, there isn't a rule about wearing masks in the disciplinary code or procedure or policy, but it was placed on notice boards and there were educational input by managers. Then is the rule reasonable? And this is a check because sometimes rules are phrased in, and I think, frankly, unreasonable terms. So
there was a helpline query about someone having to work overtime. They were instructed to work overtime in excess of what's contained in the BCA.
Yeah.
Clearly, that's an unreasonable rule.
Correct. Yeah. Was the employee aware of the rule or ought to have been aware? And it's not unusual at the point of your inquiries to remind to be job where the employee said he didn't or she didn't know anything about this rule. And that's when you would be going to the evidence that you hope management has led, that there are educational programs where, or there are opportunities where an employee must have been made aware of the rules. Now, these mask cases have all turned on the fact that although there might not have been a rule written down, employees must have been aware that you don't go out hugging employees without a mask on.
And is it a fair defense to say, I didn't know that there was a rule that you can't assault an employee at work?
No. the Labour
Because
Court,
you ought to have been aware.
The Labour Court says there are a lot of practices, forms of behaviour which don't have to be written into the rules, which an employee must know. Like, you must be honest, you can't assault. Then was the rule consistently applied? This is sometimes called the equity principle, although our courts have said it's not really a principle, it's just it's an aspect of substantive fairness. Now, it's quite interesting that it seems on one level the law always requires you to treat every employee the same way. But there's a similar kind of, call it a principle or practice, that you've got to take into account the peculiar circumstances of that employee, what we call mitigating, aggravating circumstances. And so it's absolutely inevitable and appropriate that there will be inconsistency. But generally speaking, you as disciplinary chairperson must say that in the past we've always treated this form of misconduct in this way, and I'm obliged to follow that. Then did the employee break the rule?
That's the evidence.
That's the evidence phase.
Yeah.
Yeah.
And then what is the fair sanction?
And here's the moment of anguish for the chairperson. What's the fair sanction? And yeah, that's a hard decision.
Yeah. So, I mean, there's a very useful checklist. The books behind us have just collapsed. I don't know whether that's an indication of
it's webinar fatigue.
It's webinar fatigue. We've got about 8 minutes before the end, which we should finish. So if you are a bit fatigued, hang in there. We won't be much longer before we start taking questions. But that's a very simple checklist that a chairperson could use, having heard all the evidence, go through it, and it might help you coming to your conclusions. Just on this issue of deciding the outcome, obviously you've got to take into account mitigating and aggravating factors. Again, this is a three-phase process, which I've outlined to you previously with the table tennis and the ping pong ball moving backwards and forwards across a net. Management, because they present their case first, they have the onus of proof, they would normally go first, and they would motivate what aggravating factors exist. This person was under the influence of alcohol at work, he was working with heavy machinery, there could have been a serious problem there, other people could have been killed, etc., etc., etc. The ball then shifts across the net to the union, and the union rep might be saying, well, this is his first offense, he's never been found guilty before, etc. And then the ball shifts back across to management, and they can address any issues that may have been raised by the union that they haven't dealt with when they first addressed you on those issues. So again, as chairperson, make sure that you control this process and allow both parties to have their say and to comment on each other's submissions. Normally, this phase is just the parties talking to you, but it is possible that disputes of fact occur even at this phase of the process. For example, management might be saying this employee was given a previous warning 8 months ago for a similar offense. The employee might say, no, I wasn't, I was never given a warning. Well, how do you now deal with this as chairperson? Because there's a dispute of fact over an issue that may be important that you've got to take into account. Well, you would have to guide the parties and say, look, there's a dispute of fact here. You need to call, if you want me to take that issue into account, you need to call a witness to prove your version of events. And management would have to call the manager who issued the warning, you'd have to produce the warning and see if it was countersigned by the employee or who gave it to the employee, etc., etc. And all that evidence would need to unfold. So don't be shy if there are disputes of fact to redirect the parties back into an evidence phase if it's necessary. And again, when should you as the chairperson ask the questions? I mean, say in this case, management have spoken about aggravating factors, about that this person was working with heavy machinery, etc., etc. The unions have their comments, and they've said, you know, this is his first offence, clean record, etc. No one's raised the issue of his length of service, which you think, as the chairperson, may or may not be an important factor. When do you raise those issues? Again, if both parties, so you don't raise it too early or too late, allow management to make their submissions, allow the union to make their submissions. They both had an opportunity, but they still haven't addressed what you think may be important issues. Then raise the issues with the union and say, you know, neither party's raised this issue, and which may be a factor. What's your view on that? And ask the questions. Again, allow the person to comment, and then the ball shifts back onto management side, and they can respond both to issues raised by the union and to you as the chairperson.
So we come to the moment where you've got to disclose what decision you've made. This has got to be in writing, generally speaking. And our advice is that you do it in the simplest terms possible, so they can be understood by the employee. I think the best judgments written by high court judges are those which are written with the people in mind. So I remember that you've got to give reasons. It's not the outcome, but the reasons. And so it might be along these lines. I find that you are guilty of misconduct because there is clear evidence or undisputed evidence that you came to work with a blood alcohol concentration of 0.008. You were seen to have bloodshot eyes and smelt of alcohol. Those are the reasons which have resulted in your decision to find there was misconduct. As I said, it's got to be in writing. And then some companies allow an internal appeal. It's not obliged, you're not obliged by law to have an internal appeal, but you should advise them if there is a right to appeal. But you are required in terms of the code of good practice to tell the employee that they've got a right to refer the dispute to the CCMA, which must be done within 30 days.
And we've got a simple template which we think would be useful for you as chairpersons. And paragraph 1, details of the inquiry. What dates did the inquiry occur on? Who was present? Just some basic factual details, a short paragraph. Paragraph 2, what were the allegations against the employee? 1 sentence. Paragraph 3, a brief, and I emphasize brief, summary of the evidence led. Just who gave evidence and what did they say on the key issues involved in this case. Don't try and record everything that every witness said. It's just a summary on those key issues on which this case turns on. What were the different versions? And then reasons for your finding. As Alan said, think about in your mind at this stage of what we call the losing party, who's adversely affected by the outcome of your inquiry. They should, even if they don't agree with you, they should understand the reasons why you accepted one version rather than the other version. And here that simple checklist which we spoke about under the code of good practice. There was a clear rule, the employee knew about the rule, it was a reasonable rule, there's clear evidence she broke the rule, etc. You can punctuate it and phrase it under those headings. What mitigating and aggravating factors you took into account, and finally, in 1 paragraph, 1 sentence, what the outcome of the inquiry was. So there are 6 paragraphs there. And we're not saying you must write a 10-page arbitration award or judgment, This is 2 pages, a simple summary of events that outline the key aspects of the inquiry. So yeah, I hope that's useful to you as chairpersons. That's really all we've got to say. Just those of you who are not Worklaw subscribers, have a look at Worklaw. There's the website address, some of our key services which you might be interested in. We've got an extensive case law section. We update our subscribers weekly and monthly on important events. We give advice to our subscribers via the helpline, via email. There's an extensive labor law library on the site. There are textbooks written by this incredibly learned professor on my left on unfair dismissal, basic conditions of employment, unfair discrimination, you name it. You can access key legislation. We've mentioned this before, the model procedures, forms and checklists that you can access. We run these webinars and workshops from time to time, and we offer a free 3-day trial of our services. That's my email address, bruce@worklaw.co.za. Email me if you want to have a free trial, and you can have a look and test out these services for yourself and see if they're of any interest to you. All right, I take a deep breath. We're going to the Q&A function. Those of you who hang in there, and I see that there are over 100 of you still hanging in, so well done on lasting this long. And we're going to start to answer some of the Q&A questions which have emerged. Let's look at them. If the reasons for objection are baseless, can you ignore it and carry on with the proceedings? Don't forget that fairness has 2 aspects to it: procedural fairness, substantive fairness, fair reason, fair process. Even if it's baseless, deal with it with respect. Don't show that you're irritated by it or that it's baseless. So listen, if one of the parties is objecting to you, listen to their objection, turn to the other side and say, have you got any comments on the objection? And let them say, this is a stupid objection, it's baseless, or whatever. It doesn't have to come from you. Go back to the party who's objecting and say, you've heard their views on your objection. Do you still wish to object?
If the objection is about a perception of bias, it might be helpful at that moment to say, look, the test is for bias is whether I've had any real dealings with the other side that have made me prejudiced. Trying to break it down and say that I haven't had those dealings, and so I'm ruling that that's not a valid objection. I think if you give a reason, I think it helps.
And you can also say, and I respect that you might not agree with me, and you have every right to challenge this at the CCMA at a later stage if you wish to. All right, I hope we've dealt with that question. Second question, if they persist with objections in a disruption way, do you have power as chairman to put them into order without being viewed as you're taking sides? Alan?
The only power you really have as a chairperson is the process power. You've been appointed to control the process. And I think there comes a point where you say, I've noted your objections and they will appear in my reports. But right now, we are going to carry on with leaving the end of the evidence. I think there's a moment where you've got the power to do that. What often happens, if we read this in law reports, is that there's often a walkout at that point. And then you'll have to deal with that aspect separately.
Again, if that happens, I would say to the parties, before you walk out, and I'm going to adjourn this inquiry to give you a chance to think about it, because if you walk out, you are foregoing your right to participate in these proceedings. And so I'm going to adjourn. I would urge you to get advice, and we're going to continue this inquiry in an hour's time, the same day on the same time on the next day. But if you don't appear, I'm warning you, we will proceed in your absence. And I've noted your objections, and you have every right to challenge me by taking this matter to the CCMA at a later stage. But I would urge you not to walk out, because you then are foregoing your ability to influence this process. How do you deal with a party who is just objecting to almost everything? Maybe we've covered that. There's a certain amount of leeway that you allow, but at a certain point, you would be saying, I've ruled on these objections, and I'm going to continue with the process. And so you need to allow a certain amount of leeway and being seen to be fair, but you've got to control the process. I see there are lots of questions around objections. There's an objection. The chairperson has heard both parties' arguments. The person then asks the HR person in inquiry for their opinion or view during the proceedings. What is your guidance in terms of how should a chairperson seek guidance from HR, ER? Do you want me to answer this?
Yeah, sure.
Again, I think that the role of HR needs to be clarified upfront at the outset. And that's going to avoid a lot of confusion. I don't think that the role of HR is to take over from the chairperson and to start ruling on objections. And I think if an HR person were to try and do that, you as a chairperson should put the person in their place and say, look, it is not your role to make representations to me on this objection. There are two parties appearing before me. If you wish to make your comments, please speak to the management rep. And I'm assuming here an inquiry where you've got a management rep and a union rep who are effectively managing the cases on behalf of either party. And I would say to the HR rep, I'm going to adjourn for 5 minutes. You can speak with the management rep. If there are views that you wish to raise, please express them through the management rep, and he can convey those views to me. But it also depends on the organization and what roles you've assigned to HR persons, and that needs to be understood up front to avoid any confusion.
I was going to say that I think the principle should really be that you do as much as possible openly and not out of the formal hearing.
Yeah. All right. I see we moving on from objections. When you have very vague charges, e.g. gross dishonesty on day X, is it enough to establish common cause on the cause of action and move on with the hearing? Alan, do you want to answer that?
Well, with that kind of vague charge, you're hoping that in the introduction, the employer rep is going to be saying what form the dishonesty took, so that you as chairperson are getting a fuller idea. I think you need to alert the the employer's rep that the charges are very vague, but so the evidence that needs to be more specific. But I think you can move on with the hearing. I don't think a vague charge like that stops it, but you need to, if it becomes clear that as it goes on, that the employee hasn't had a chance to prepare on that, if the employee doesn't know what's being referred to, you might have to adjourn.
Yeah, okay. There's a question, will this presentation be made available? Yes, it will. We will put the video up on the Work Law site a few days after the event. In a case whereby the employee is under the influence in a staff meeting and exhibit bad behavior in full view of witnesses, the employer did not get an opportunity to test the employee, but the symptoms were fully observed. Can the employer pursue this case relying only on the witnesses? Helen?
Yes, that is possible because there's a fair amount of case law. You can use the helpline query and we'll give you the cases where a person's behavior is taken as evidence for intoxication or being under the influence. So a test is only one way to do it. And if there's a number of witnesses who can give evidence, it can be pursued.
No, I think you're appearing.
Okay.
I think we can see that's just moving on. Okay. In cases with lengthy video footage, it can be difficult to maintain the examination in
Chief
or cross and re-examination strictly. I take a fluid approach and ensure everyone has an opportunity to ask questions. Do you have any thoughts on this?
I think this is almost like a inspection in loco. You are all as a team watching. When I say a team, I mean all the parties are watching something. So if the rule about an inspection in loco is you are all together and anybody's allowed to say, can you notice that at this moment this is happening?
And an inspection as loco is when you depart from the room where you're conducting the inquiry and you go and visit the scene of the crime where things occur.
Yeah. So the rule is that for an inspection, both sides are able to say, I'd like you to notice that it's the space between that door and this is 4 meters, and everyone agrees, as it were. And so I would think by watching all the people watching the video at one time, you say up front, as things happen that are crucial to your case, I want you to mention it. We can stop the video at that point. So I think your approach sounds like that's what you're doing. That strikes me as to be procedurally fair. Bruce, is that okay?
Yeah.
Yeah.
In matters with length, okay, we've dealt with that one. How do you handle evidence where it is said this? He said that, for instance, an insult case.
Yeah. Well, this is your typical case where there are 2 versions which are almost contradictory. He said this and they said that. And the job of a chairperson is to then use the tests of probability, what's probable, reliability, those kind of common tests of how do you balance one version over another. Is that right?
Yeah, and there may often be other factors. If someone was insulted, they burst into tears, they went into an office next door and they said, this person just said this to me. And often these sort of things happen in sexual harassment cases. Well, what motive would that person have had to do that unless they were insulted? Perhaps they do have a motive.
Yeah.
And so you've got to look at a basket of factors. It's hard, but look at a basket of factors. Look at all the evidence.
Motive, yeah.
Was it overheard by someone else?
Which is more likely? Which version is more likely on common sense grounds?
Yeah.
It's not likely that person bursts into tears and rushes to another office unless it's been triggered, and then you say, well, what triggered it? So it's really a common sense approach rather than a strictly legal one. We do have some cases on work law which illustrate this well, when there are 2 versions how you go about it. Once again, if you email us, we can give you the cases.
Yeah, and so often we've had employers say, well, because there was one version, there were only 2 witnesses. There were no other witnesses. There was the person who said it and the other person who it was aimed at. Well, there's no evidence. We can't determine it one way or the other. Well, you do have evidence. You have the evidence of those 2 people. How do they stand up under cross-questioning when they are questioned before you in the inquiry? And you can take into account how they responded to questions as possibly a means of saying, well, I think it's more probable that this person is telling the truth rather than this person.
Yeah.
Sorry, I have to lean forward to try and look at the question. This is a long one. The disciplinary code for bargaining unit employees requires that the hearing be disposed of within 10 days after having completed the investigation. It's my experience that almost 95% of the time, the employer does not comply with this requirement. The gentleman with the checklist mentioned that
The check shirt, that's me.
check shirt with a check shirt. I thought there was an R missing, so I changed it from what I thought the word was to list, but the check shirt. Alan mentioned that employers need to stick to their own standards.
Yeah.
How should a presiding officer deal with matters of this nature when the employer obviously are outside the timeframes contained in the disciplinary code, given the fact that the code are a product of the collective agreements? Yeah, I mean, in most time periods written into the Act, into guidelines and so on, there's a condonation process which allows a party to explain why they are outside of the time limits and why they should be entertained, even though they, like, you've got to refer a dismissal dispute to the CCMA within 30 days. If you don't, and there's a list of factors that one takes into account in deciding whether to then still allow this person, this applicant, to refer that matter. How late were they? What were the reasons they were late? How much prejudice was there to the parties, their prospects of success in the matter? And I mean, I think a common sense approach would be applicable in most of these cases.
Yeah, I would use in the condonation tests. There's always the main one about prejudice.
Yeah.
Is there prejudice by the delay? And it can be real. I mean, an employee being charged eventually outside of this this time period might have lost a valuable witness, and then there's been real prejudice caused by the delay. Also, memories fade over time. So I think the prejudice test becomes real. I think, to answer the query, it doesn't mean that because you haven't got there within 10 days means that the employer is now no longer enabled to carry on the disciplinary process. You must, as a chairperson, go through the condonation process.
Yeah, and I think fair. The basic rule here is fairness. What is fair to both sides? And if they come on, your example you gave, there was a 10-day time limit. If they come on the 11th day, I mean, really, how much difference is there between the 10th and the 11th day? Yes, there hasn't been strict compliance. Was it there for a particular reason? I mean, if you come 5 months later, well, clearly that's a major problem. But I mean, I would apply a common sense approach to these matters. Does a presiding officer have the power to dismiss disciplinary cases? There are senior management that believe that presiding officer does not have the power to dismiss a disciplinary case. I'm not sure what you really mean by to dismiss the case, but certainly if there's no evidence placed before you to substantiate the allegations that have been made, you would dismiss and found the person not guilty, if you want to use legal jargon. I know in some organizations, the presiding officer only makes a recommendation to senior management. We think that's problematic because, I mean, it's fine if the manager makes a recommendation that this person be found not guilty or only given a final warning. If that recommendation is accepted, well, then there's no problem. But if a manager chairing the inquiry makes a recommendation that this person be given a final warning, and more senior management says, oh, no, they should be dismissed. Well, I think there are possibly procedural problems there, because the person who's then making the finding hasn't heard the evidence, hasn't seen the witnesses giving evidence, hasn't been influenced directly by the evidence that's been led. And I think you're opening yourself to potential cases of that being overturned if that's challenged at the CCMA.
There's another kind of case where dismissal issues arise and where the matter's set down for the hearing, and then at that stage management says we're not ready to proceed. Can a chairperson at that moment say, look, for management, you're bringing this case and why is there a delay? I'm going to dismiss it. But I mean, can that happen?
Yeah, I mean, I think, again, as a chairperson, I would invariably grant a party at least one adjournment. If they come before the inquiry and they say, we haven't had a chance to prepare our case, etc., whether it's management or the union, I would invariably grant at least one adjournment. But if it continues on and on and on, at some point you can say, because one of the principles of action is that you take it within a reasonable period of time. And if the management's not doing it, I would then at some stage, again, probably chuck the case out. Yeah. All right, how are we doing? All right, we've still got over 100 people hanging in, so we hopefully are making some sense. If the admission of the evidence does not come up, do you as the chair need to raise it, or can you simply accept the document or the footage? I think by just not raising it, it then creates doubt, and at a later stage, there's uncertainty whether this document was needed to be proved or not. And you get towards the end of the inquiry, and the union says, well, no one was ever called as a witness to prove this document. So when I used to arbitrate a lot, whenever documents are put in front of me, my first question is, what is the status of this document? Is it admitted, or does it need to be proved? And if it's disputed, what aspect of the document is disputed? Do you accept that these are the minutes of the inquiry, that you're concerned about clause 4 not correctly reflecting what the conversation was on that particular point? I think similarly, you as chairpersons, when documents are placed before you, you need to say to both parties and explain why you're saying it. Say, what is the status of this document? Is it admitted? Because I need evidence as the chairperson if it's not admitted. If it's admitted, then I can accept this document and take it into account. So parties help me. Is this document admitted or not? So I would do that with all documents which are placed before you. Don't leave it uncertainty.
Definitely.
Yeah. Ellen says we've answered the next question. When to ask questions and what type of questions to ask as chairperson. I think
also not to ask. So what should you avoid asking?
Well, I think leading questions.
Yeah, leading questions.
I mean, I think you need to ask any. There's nothing worse as an arbitrator or a chairperson than going home that night to decide the outcome of the case and you don't know the answer to certain key questions because it was never told to you at the inquiry. If that does happen, there's nothing to prevent you from reconvening that inquiry and saying, look, I went away and it appears to me that there's some quite important issues here which are going to open, which are going to influence me in coming to my conclusions. And these are what they are. And I'd like both parties to give me their views on these issues. I've done that in arbitration before, because you can't guess the answers to these questions. And if they are going to influence the outcome, rather know the answer than trying to determine the outcome without knowing the answer.
Yeah.
You've done that, Alan, before. You've re-adjourned inquiries. What if the not guilty finding arises from management's poor presentation of the case or certain procedural aspects as per the company rules were breached, which could put the company into dispute? What do you do in that case? You want to chat about?
Well, can I say something? That I think that the legitimacy of a disciplinary procedure means that sometimes management's going to lose.
Yeah.
And they need internally to get their act together so that if you as a chairperson rule that in fact there wasn't enough evidence led by the company or the employer to justify a finding, or alternatively the procedures were breached or not followed, then you've got to take that step as a chairperson, and the employer must jack up the systems.
Yeah, look, I mean, I think that the fact that they conducted the inquiry badly doesn't mean they should have a second chance to do it all over again and do it better. If, however, you say you determine a matter, and after the event, new evidence came to light which was never available previously, which was never available and could never have been led at the previous inquiry. It's possible to reopen an inquiry on the basis of new evidence that has since become available and to conduct a further inquiry. And just, I mean, we might also comment at this point, Alan, I mean, there are these cases as to say, well, when can the employer hold a second inquiry?
No.
And there are judgments which we can give you, which are on work law, which says fairness applies to both sides. And if a chairperson of an inquiry has effectively committed misconduct and has not conducted the process properly, or has not applied the company's sanctions as they exist, it might be open to the employer to re-hear that matter before a new or different chairperson.
Yeah.
Yeah. So there are cases in which you can conduct a rehearing, but they are limited, as Alan says. Right. Is the issue, Alan, your eyes might be better than mine.
Is the issue of consistency only a consideration when deciding on the appropriate sanction? Oh, yeah, okay. I just read a case where the chairperson had to deal with this issue. The very first objection raised by the employee is he was the only employee that he knew of had been charged with a form of conduct which was routinely accepted. So consistency could be challenged right at the beginning. I shouldn't be charged.
Yeah, I mean, well, why am I being singled out?
Because often there's a rule, but there's a workplace practice that carries has a set in. And the case involved allowances for people who are traveling. And it was accepted that a person could claim the meal allowance, even though they might be back at home. A practice had crept in that it made it acceptable to do something which was in violation of the rules. So a chairperson might well be faced with having to work out a consistency right at the beginning.
Yeah, and I mean, it goes to that checklist. Is there a rule? Has it been applied? And so on. Well, if this rule's not being applied to any other employee, well, then it isn't really a rule, and you can find the employee not guilty. It comes up mostly at sanction, but it can come up earlier as well.
Can I say that the courts have ruled a number of times that if you're going to make the allegation that there's been inconsistency, you've got to come up with fairly clear, specific examples to show that there's been inconsistency. So you need to come up and say, oh, there was X who did this and wasn't charged. There was Y who did this and wasn't charged. It can't be just a vague allegation of inconsistency. It's got to be referenced to specific cases.
Okay, there's been a request that we have a break. We've been going for an hour and a half. We do have a number of questions still to answer, and there are over 100 people still logged on. So we're going to have a 2 minutes or a couple of minute comfort break. And then we'll continue answering the questions which are there. And we're going to mute ourselves for 2 minutes. All right, we're going to carry on and answer the balance of the questions. Alan, do you want to read out the next question?
What if the guys bring their case studies on the inquiry to justify their case? And that supersedes the decision, the company or the rule or court decision on similar matters. I think what I hear from this question is people who have done some legal research and have found a case that looks very similar to the one that you are hearing. Now, all court cases have some kind of authority, and certainly a case decided by the Constitutional Court has got particular authority all the way down to the Labour Court or the CCMA. But every case turns on its own peculiar facts. But as a chairperson, if someone gives you a reference to a court's decision, I think you must give it some kind of weight, which means that you're going to have to do some research. You need to send us a helpline query and say, can you get us this decision? And if the decided case by, say, the Labour Appeal Court is on all fours with the case that you have heard, then I think you must give us some authority to that. You must be persuaded.
Yeah. Just to add that there's been a recent, I think it was a Labour Appeal Court judgment, but we can give it to you if you ask us, which said, you've got to apply the principle of applying the same approach as previous cases. Apply this with caution, because an employer is not required to repeat a mistake it made previously, where it didn't charge people previously and now it's appropriate to charge people. So apply that rule with caution, because as Alan says, the facts of each case become important. Next one, Al.
What weight can you apply to previous warning that was never signed, also not formally challenged by when you're deciding a sanction? What weight do you give to a previous warning which wasn't signed by the employee or it was never challenged? Well, I think the one thing is that I think it's very common for previous warnings not to be signed. And I think there's any legal obligation to a signature on a warning. It's the employee's decision to issue a warning. So
all the signing does is prove that it was given to the employee. So if there are other means to prove it was given to him, and the person who gave it to him or her can be called as a witness to say, I gave this employee this warning on the 3rd of October, and that's proof that they were given the warning.
But the issue of not challenging it might be worth exploring, and it might be worth putting to the employee. And this is perhaps a question that needs to be framed in a very open-ended way. But you could say, look, you were given this warning, and is there any reason why you didn't challenge it? And a lot of people say, I just didn't want to make any more fuss. I just wanted to put it behind me. But I didn't agree with it, and I think it was unfair. It might be worth hearing that.
Yeah, I mean, I think that there are cases, and this applies particularly in respect of final warnings, where someone is now being dismissed, partly because of the final warning that was previously given 5 months ago. And I've seen judgments saying that final warning wasn't challenged then, and it's too late now to come and try and dispute that was an unfair final warning given to you 5 months ago.
Yeah, the fact the person doesn't challenge it doesn't now mean they can reopen it. All right. Down, we need to go down. Yes.
In aggravation.
Yeah, in aggravation, can the company bring a warning of other misconducts and it's not linked to the alleged charge at hand? Okay, this is quite interesting. I think the norm is that you want to show the person's guilty of there's a pattern of misconduct. But there are cases which say that an employer is entitled to look at the employee's behavior overall, even expired warnings, to see if there is a pattern of disregard of the employer's rules.
Yeah. I mean, as a general rule, there would have to be a similar offence of a similar nature for the warning to be taken into account. But we've often encouraged employers to, if there's a pattern of behaviour, the person comes late then they're rude to a customer, then they don't submit a monthly report on time, then something else happens. It gets to a stage where you can say to this employee, listen, you're clearly not complying with the company's rules. There's a pattern of behavior here, and we're giving you a comprehensive final warning, which applies to all offenses. And if you break the company rules again within a reasonable period of time, then we're going to take further action against you, which may lead to you being fired. So that's I've often encouraged employers to develop this concept of a comprehensive final warning in appropriate circumstances.
Yeah, but the direct question is, say the person's being charged with
late
coming, and they've got a charge for assault. They are unrelated, and
yeah.
you're going to treat them. You're not going to take the one form and make the more recent case more serious.
You're right. Alan, how to implement or refer to the
common law? Okay, I think as a chairperson, remember you're controlling the process, and it's important that you be seen to be fair, and you need to explain. Now, what's an example of the common law here? Can you think of an example?
On the case that we were dealing with, or just about any case?
Well, common law also refers to judge-made law. Let's take the exact example that there is a case which says that you are entitled to look at the behavior of someone who seems to be under the influence of alcohol. Now, that case is part of our common law because it's been decided by a judge. So I think as a chairperson, you can say, look, there is something in the cases that have held that it's not just a blood alcohol test that is an indicator of intoxication, that the person's behavior is also an indicator. So I think you could introduce it in a kind of educative way.
Yeah, I think where there's something which is in with your knowledge and not within the knowledge of the parties appearing before you, where you might know of a case that's important, an important principle. I think again, it's your obligation to raise this with the parties, and this would probably be in regard to what sanction ought to be applied. And you should say to the parties, using layman's terms, not legal terms, but there is this judgment that you're aware of that says X, Y, Z, and I'm bringing it to your attention so that you can comment to me if you have any comments to make, how important you think that might be in this case. You're allowing the parties to have their say. Again, it's the audi alteram partem principle, the right to be heard. As an arbitrator, if we find and know that there's a case on points with the matter that's being dealt with by the parties, but neither of the parties have raised this judgment during the process, we have an obligation to bring it to the attention of the parties and allow them to comment to you on how important or applicable that judgment may or may not be in the case that you're currently dealing with.
Yeah. I think the next question here was, I battled with the network in the first 15 to 20 minutes. I'd like to watch the whole webinar again. How can I access it? Well, as Bruce said, for the next couple of days, a recording of the webinar will be up on our site.
I hope that was only an ad hoc comment and not all of you battled to access it, but hopefully not.
Okay. I often allow parties to submit closing argument and mitigation aggravation in writing after giving evidence and before making a finding. The union failed to submit mitigation as part of the closing argument. They referred the dismissal to the CCMA and claims the proceeding was procedurally unfair as I did not give them an appropriate opportunity to present mitigation after my finding of guilty. How would you respond? Well, I suppose it's,
well, if you gave them the opportunity and they had a time period within which to do so, but didn't do so, well, you know, they were given the opportunity. Just on this point, I mean, you've heard me saying over the last hour and a half on quite a few occasions, allowing both parties to comment on each other. And if you do have this practice of allowing closing arguments to be given in writing, I think it's quite important to manage that process as well. I would then say both parties need to submit their comments to me in writing by Monday, the 13th of September. And then both parties have a further opportunity, a further 7 days, to comment further on issues raised by either of the parties in their closing arguments. So in other words, they have an opportunity to address issues that were raised by the other party, which they weren't aware of. Because otherwise, again, you haven't given both parties a chance to comment on each other.
Yeah, I think that's right. Are parties required to share evidence with each other before the hearing commences, or should each party only see the evidence for the first time at the hearing? It's quite interesting. This question is an interesting one. It's informed by what's happened in the criminal courts. There was a time when prosecutors could keep their dockets completely closed, and the person charged with a criminal offence would come to court and not know what was in the dockets, not even know if there was evidence in the dockets which assisted them. So in criminal law, the tendency has been to make dockets open, so an accused person knows the full range of evidence there. A disciplinary inquiry is not a criminal case, and the only instance where I would say that documents should be, or evidence should be shared in advance, is where if it's given later, it'll definitely result in an adjournment for the person to be able to respond to complicated computer evidence which needs to be gone through. But there's no obligation to share evidence ahead of time. But if you want to have a smooth flowing disciplinary inquiry, it might be a case, in some cases, I think, to say the case is going to be based on this computer printout and share the things. It's just a safe.
Yeah, I mean, I think also it's important to focus on what evidence is being used. In other words, if you're a management rep appearing at an inquiry and you've got a written statement from the witness, and you're going to use that statement as your guide to ask questions of the witness when he or she verbally gives their evidence at the inquiry, that statement is not evidence. What the person is saying when they give evidence as a witness verbally, that's the evidence. So the other side, as it were, is not entitled to your statement. That's your statement, that's not the evidence. If there's documentary evidence, I mean, there's a general principle, largely at arbitration, but I think it equally applies to internal inquiries, that you shouldn't be ambushed by documents. So in other words, if I was the union and I was appearing at a disciplinary inquiry on behalf of my member, and the company arrives at the inquiry and puts a bundle of documents on the table, and is leading their witnesses through the contents of those documents. I've never seen those documents. I'm going to ask for an adjournment. So in order to prevent cases just being adjourned unnecessarily, there's a general rule that if you're going to use documentary evidence, that the other side can at least see that in advance, so that they can prepare their questions in advance to ask questions of the witness. Because the alternative is that the chairperson is going to be faced for a request for an adjournment, which they should probably grant.
The next question is, can provocation serve as a defense to assault? The answer is yes. There's some interesting cases, and if you've got a specific case that you are dealing with, please use the helpline and we can send you the authorities on this. But provocation does not, there's a proportionality rule. You can't use provocation to viciously assault somebody, but provocation allows you perhaps to respond to defend yourself, but not to viciously assault somebody else. So there are limits. Provocation helps to some extent, and it might justify a certain kind of response, but not a vicious response.
And it's probably more going to come, and I think where you're going with that question, it's probably more going to come up as a mitigating factor, having made a finding of assault, rather than to finding you not guilty of the assault in the first place. So, but it can be both, as you said.
Yeah.
Yeah.
The next question is, I know that's not one size fits all, but I normally try not to limit cross-questioning time, especially from the accused person's side, in order to avoid being perceived as biased. Okay, and this is a real issue when questioning carries on and on and on, and it's actually doesn't touch onto the key issues. And sometimes the chairperson needs to kind of say to the person doing the questioning, can you help me understand where you're going with this line of questioning? Because it does seem to be touching on stuff that is taken for granted or is admitted.
Or has no bearing.
Or has no bearing
on the issue.
So I think there are ways to jog the questioner to return to the heart of the matter. And I agree that your motivation is very good. You don't want to be perceived as being biased, but there are ways to say, look, I'm not following. Why are you reading this evidence?
Yeah, I mean, as I think that you are hinting in the way you've asked the question, I'd be very cautious of doing this. I would allow a certain amount of leeway, because you are going to be accused of being biased if you cut off their ability to ask questions that they think might have been important. So allow leeway. What you sometimes see arbitrators doing, they just put their pen down and they're not taking notes anymore, and they're just looking at you, and they try to signal to you, this is going nowhere. These questions are not pertaining to the issues that we need to be dealing with.
Yeah, there's just one follow-up question on the next help query. What is a reasonable time to allow for cross-questioning? Sure, there can't be.
How long is a piece of string? You can't put a time on.
It's going to be dependent entirely on the circumstances, and I think your question is, the dangers of bias, so I would not put limits on. All right, we've got a long question here along these lines. 8 employees all committed the same offence. Each person was caught on video. Each disciplinary was held separately, as the union objected to video footage being shown to others not on the video. The shop steward was also caught on film. However, he was about to commit the same misconduct. He spotted the camera and walked away. The employer referred to common purpose and said that the video illustrates that there was a practice of this misconduct, and that the shop steward's behavior on film shows that he himself participated or at least knew of this practice. The videos of the other employees were not shown at the inquiry. The union did not object, however, stated that they want absolution from the instance due to no evidence being presented that he was guilty of misconduct. At the CCMA, the union is objecting to the fact that I chaired all 8 inquiries and that I used my knowledge of the footage presented in the other inquiries to establish proof that was not presented at his inquiry. Okay.
Sure, it's a long question. I think I might have got lost there, Eileen, halfway through.
Okay, but I think I'd like to tackle one aspect. You can come with others. There is authority which says you can't use evidence presented in one inquiry and use it in the second. You got to, as a chairperson, go on the evidence presented in that inquiry. All right. So if you used evidence from the 8 employees and used it in the shop steward inquiry, it probably was an unperceived mistake.
Yeah. I mean, to me, it raises the issue of when you have an offence committed by a group of employees, do you have one inquiry in respect of all the employees, or do you have 8 separate inquiries? I think by and large, as a general rule, I'd go for a group inquiry. And my reasons are this. Firstly, it's very difficult for the chairperson who's conducting 8 different inquiries to not be influenced by the evidence that he or she has heard at the previous inquiries. How do you wipe that out of your mind? it's almost impossible to do that. And you're then falling into the risk of being influenced by evidence previously led, which was not led in this particular inquiry, and this particular employee hasn't had a chance to observe and see. The other option then, if you're having separate inquiries, is that you have 8 different chairpersons conducting 8 different inquiries on more or less the same facts. And they might well come to different conclusions based on how the witnesses perform at the different inquiries. And the witnesses are probably going to get better and better as the inquiries go on at shaping their versions, etc. So I think as a general rule, I would hold one inquiry where the witnesses on the key issues involved give evidence once on those factors, but that there's an opportunity, if there are different circumstances applicable to the different employees, they do have an opportunity to raise those different issues as well in the group inquiry. And certainly under mitigation and aggravation, there might be different factors applicable to each employee. So it's a more difficult inquiry to chair because you're conducting a group inquiry, but also allowing for individual issues to be placed before you at the same time. But the dangers in that route are far less than the dangers in having 8 separate inquiries.
Yeah, I agree. Just want to comment on the reference to common purpose. This is quite a complicated legal concept, which when a person associates themselves with misconduct, they might not be the ones found with stolen property in their hands, but they were part of a group. That's called, there's a doctrine called common purpose. Now, as I'm just imagining here, you do this shop stewards hearing last. You've already heard 8 different inquiries. You've seen the video. You know the shop steward is there. Okay, so now if the shop steward denied being there, you couldn't use your knowledge that you've seen him in the video in the other hearings to say, I'm making a finding that you were there. You are, if he says no, management is going to find evidence to establish that he was there. So it seems very nonsensical in what's meant to be in a formal system of administering misconduct hearings. But I don't know, Bruce.
No, it's not.
Yeah, okay.
Just above that, Alan, there was another question. Do you need to physically have a physical request for a meeting to consult with the union, or by sending a notification via email? Will that qualify as consulting if the union rep is charged? I think, don't forget that the phrase used in the Code of Good Practice is inform and consult. So informing is not good enough. You've got to inform and obviously attempt to consult. And so an invitation to consult. But clearly, if a union just doesn't take up the opportunity and avoids consultation, they can't later claim that they weren't given the opportunity to consult.
May the chairperson refuse to take advice from management calling for a penalty, not to be dismissal, but a final warning only or on not too serious an offence. May the chairperson refuse to take the advice from management calling for a penalty, not to be dismissal. Okay, so you've got the employer rep who's saying, we don't think this is a dismissal case. We would be happy with a final warning. Do you have to accept that advice? Or do you say, actually, I think this is a really serious matter?
I think you as the chairperson have to decide the outcome, and it's got to be a fair outcome. You've got to take into account the views of the parties, and but still you've got to determine the matter on the basis of what you think is fair. That's your job in the inquiry.
Yeah.
You know, this, and I'm going off point here, but it often comes up where there's been an assault case that's taken place at the workplace. 2 employees have had a scrap, they've had a full go at each other over something, and they sort things out. They apologize to each other, and both of them saying, look, neither of us want any action taken against the other person. That's not the issue. Irrespective of what the employees involved in the assault might say, you as the employer need to deal with an assault that's taken place at the workplace, and deal with that appropriately.
Yeah.
So, I mean, I think a similar approach here. Yes, you've certainly got to take into account and be open to persuasion by the union rep and by the management rep, and you've got to show that you've got to take into account. But you've got to decide what the fair outcome would be. So when you write up the conclusion of that inquiry, you would be saying that the management rep thought this was only justified a final warning. But I have a different view, and these are my reasons why I have a different view, and I'm going to impose a more serious sanction if that's what the case is.
Next question. Can you as a chairperson tell management they will not be able to lead evidence of intent on a charge such as fraud before they could even start leading the evidence? All right. I'm trying to imagine where this would arise. I think you need to, it sounds quite legal to me, this question, because remember what the Labour Appeal Court is saying, you're there to judge, has there been misconduct? Now you've got fraudulent action going on here, and the fraud is usually where there's prejudice caused to the employer. And if you can't prove intent, you might say, well, there was still a form of misconduct here. And I'm not too sure why you would want to say to the management, I'm not allowing you to lead evidence of intent. But I agree with you when you say you should start leading the evidence of the actual story. What happened? What looks like fraud? That there was some kind of corrupt dealing going on. And I think that the intent would probably be part of that.
Yeah, I would as a chairman be very, very wary of ever saying to any party, I'm not allowing you to lead evidence on X. Because immediately they're going to have their backs up and they're going to accuse you of being biased, because they weren't allowed to present their case as they saw it. So I would very, very seldom, if ever, be saying to anybody, I'm not going to allow evidence on ABC, XYZ. Allow the evidence to be led, and attach what importance you think is important to the evidence that's led. Even where parties are leading evidence which is off the subject, I mean, they are not legally trained. It's maybe the first time that they're ever doing this. Allow them some leeway. Don't be too strict. Don't be too formal with the parties.
Yeah. Next question is further to the question about it being permitted to share evidence with parties in advance to save unnecessary adjournment at a hearing, for example, video footage, meeting audio. Does this mean that the chairperson must view the evidence in advance as well, so that they are not disadvantaged and can make a fully informed decision?
I mean, I don't think that there's a rule one way or the other. Sorry, we probably haven't got much time, but brief story. My first arbitration I ever did, I appeared before parties and they presented a bundle of documents, about 500 pages on the table in front of me, and started leading evidence. I didn't have a clue what the case was about. Thankfully, at the end of the first day, they adjourned and they settled the matter. I had no clue what was going on in that case. So thankfully, I didn't ever have to give an award. But if you arrive as chairperson and there is documentary evidence and you think it's important that you have a look at that before you start hearing witnesses, you can ask for an adjournment and say, I need to go away and have a look at this first so I can apply my mind properly when your witnesses give evidence. And I also think the fact that you as chairperson was given the evidence up front does not mean that that is procedurally unfair.
Yeah. But I must say, I would be reluctant as the chairperson to be going through evidence alone.
Well, you were just given the bundle of documents which is going to be used in the inquiry coming up next week. It's fairly common that we as arbitrators get given a bundle of documents in advance of the inquiry.
I would prefer that bundle to be given by consent of both sides.
Yeah, no, I mean, as it's given to the other side,
Yeah.
it's also given to you as the
Okay.
chairperson.
Yeah.
Yeah, so I mean, I wouldn't accept the bundle unless it's been given to both sides of the in the proceedings as well. Last two queries, I think. Two more queries.
How do you respond to an allegation that the respondent is being targeted when the hearing is based on a tip-off and subsequent investigation that led to the disciplinary process? All right. It's almost a background story before as to why someone has been charged. And there's almost as if there's been some kind of inconsistency, that they're only being charged because there's a tip-off. But I think the reality is that if the person is guilty of misconduct, the fact that someone's been tipped off about the misconduct is actually quite irrelevant. If there was misconduct, there was misconduct.
Yeah.
And if the person's being targeted, well, that might be true. But if they were guilty of the misconduct, that's what you as a chairperson must focus on. I don't think you throw it out of court. You can't dismiss the matter simply because the person might have been targeted. That's the motive. I mean, that every employer has got a discretion whether to proceed with the matter or not.
Yeah, I mean, do you want to talk a little bit about it in
Well, I think that, I don't think this question imagines the person's been entrapped, but there are firm rules that an employer can't set out to almost induce an employee to commit some kind of misconduct by falling into a trap. So yeah.
Yeah, but if there's a camera up and that catches you doing something, that's not entrapment.
That's not entrapment.
No.
But if the situation is so rigged that you fall into a trap,
yeah,
then that evidence will be regarded with greater suspicion.
All right.
Surely, if you use 8 different chairpersons and there are different sanctions, you will then be accused of inconsistency. Yes, you're right. Each person's involvement in the incident should show separate video footage of their individual involvement. For example, an application form is filled in for a mortgage bond, but 2 people were involved in an incident with a salesperson and the creditor prover. Their involvement is different. Then there is knowledge or bias by the chair to carry across to the other hearing.
I mean, I think that's highlighting the point that we made, that, I mean, those are the dangers of having different inquiries. And I think it's a more difficult inquiry for the chairperson to conduct, but if there's similar or overlapping evidence involving 8 different employees, have one inquiry, but within that inquiry, there may be a need to leave individual evidence about the individuals, which is different to some of the others.
Yeah.
So it's like a combined group inquiry, but with sufficient space to allow individual evidence to be led for particular matters.
Yeah.
I think we've come to the end of our questions under the Q&A function. So it just ends off for us just to thank you all for hanging in there. We hope that you've enjoyed this. Please give us feedback. We would appreciate your feedback on whether you thought that this was worthwhile, whether it was helpful. And if there are any other subjects that you'd like us to cover in future webinars, please let us know. Thank you.
Cheers.
Thanks a lot. Have a good day.